Okay, very welcome. Välkomna to this morning's seminar on technology infringement and patent disputes in China. My name is Thomas Randus. I am the country manager of Rouse in Stockholm, and just to give a little brief about Rouse, for those who do not know us. Rouse is a consultancy firm that is active in the most difficult jurisdictions around the world. And the purpose of our Stockholm office is to aid our Nordic clients on those markets. In the past, Southeast Asia, where we have had our presence, is dominated by IP issues such as counterfeiting, and one of our major services has been enforcement in relation to those. The world is, however, changing. Our linear value networks and value chains have been converted to much more complex value networks. Companies are not conglomerates and do not conduct all of their activities themselves, but outsource important services such as research and developments. This also puts focus on control issues and why it is so important to be able to control your key assets also on markets where this common development is occurring. As we know, Southeast Asia and specifically China is no longer only the factory of the world, it is also a think tank of the world where a lot of thoughts come and where you also have technology export. So this is the reason why we also exist in China. A little bit about Rouse. We actually celebrate our birthday. We are 30 years. Rouse Stockholm is an acquisition of Rouse and was previously named IPQ. We are today 18 offices in the world, of which 4 are in China. I think the latest count, we are about 667 people. I believe this slide says 680. That might be wrong, but our size does also implicate that we also fluctuate a little bit. Today's agenda will be presented by my colleague Malin in a short bit. I will just give a little brief about Carol and Lu Sheng, which is a trade name which will appear just in short. Due to legal reasons, we have to be organized in different entities in the Rouse sphere. Therefore, in our legal services in China, we act under the name Lu Sheng, which is a law firm which works exclusively for Rouse and whose partners are also partners in Rouse. So, Malin, you've been doing some of the weightlifting for this seminar, and why don't I give over the presentation for the agenda to you? And I'll just make a Corona move so you can get into place.
Thank you, Thomas. For the agenda for the presentation today is first the introduction that Thomas has already held. Then Carol will introduce herself, explain who she is and what she has done. Then Carol will talk about the Sierra database, why it was created and what we use it for. The 2 different routes you can use for patent enforcement in China. Carol will also make a case study, explain about one of the more important cases that Lu Sheng and Rouse has run in China. All of this is approximated at about half an hour. After that, we will have questions. Thomas and I will pose a lot of questions to Carol because we were very curious about this area, and also any questions that we have from the audience. So over to you, Carol.
Thank you, Malin. Hello, everybody. I'm Carol Wang. I'm a principal of Rouse Network. I'm currently working with Lu Sheng law firm. Thomas just now mentioned is a member of Rouse Network. I've been working in Shanghai office for 18 years, and I specialized in different IP dispute resolutions. My main clients coming from different industry, such as entertainment, apparel and shoes, luxury, toys, automobile, etc. Next slide, please.
Oh, sorry.
Over the last 18 years, I can see a very clear trend that IP holders intend to shift from 100% of 100% administrative route to the litigation, civil litigation especially. So the civil litigation has become a primary tool for the IP holders to choose, especially when they try to solve the complex IP issues. Recently, we have helped several clients of ours to successfully do some landmark cases for them, such as this one, the New Balance one. We just got the judgment in this April, but it is a 4 years war, which means from the first time we filed the case until we received the first instance judgment, it had already been 4 years. The result is that the infringing parties' chain stores has been reduced from the originally 2,600 to today's 60 stores, and they gradually faded away from the market. And also, the judge awarded damages of 1.4 million to the plaintiff, our client. And on the day of that judgment announcement, this news has become one of the hottest social media topics in China, not only because of compensation of 10 million RMB, but also because the judge made a very fair and bold judgment, which means they have used the prior unfair competition right against the later registered right, which is still very rare in China. Next slide, please. For this case, again, the challenge is that the client didn't have any registered right for the Chinese nickname of Timberland, as well as a whole get-up. So what are we going to do? We have successfully used the unfair competition rights and the Chinese legal system to protect the Chinese nickname of Timberland and the whole get-up. And through 2.5 years efforts, we have been undergoing the first and the second instance judgments. And finally, the effective judgment has fully supported our claims. Next one, please. For this one, I'm not going to take time to address in more details because I'm going to talk about this case later today because it is a patent case. Next one, please. All right, because as I mentioned, the litigation has becoming the primary tool of the patent enforcement as well as other IP enforcement. So it's very, very important for the IP holder to understand the whole practice in China, especially the judicial practice in China. That's why we come up with this CL system from Rouse. Now, I just give you, let's look at what and why we have the CL system. Next one, please. I give you 1 second to read this slide just to get an understanding of what it is. All right. I hope that you can appreciate that this CL system is basically a tool with a very good data. But in addition to that, it is an analytical tool of statistics. It will bring great transparency to especially the foreign right holders, helping them to understand China's judicial practice in IP disputes. As you can see, this data has covered more than 65,000 cases and covered more than 364 cities, especially the IP courts. It has covered also over 600, and time period has lasted more than 14 years. So it's a very comprehensive database. Next one, please. From my perspective, I think every time when I do a civil litigation, I would like to check the CL database. It's very important for me to understand the different jurisdictions. In China, because of the different economic development in different areas, the jurisdiction practice varies a lot, which means even for same type of dispute, if you bring it to the Shanghai court, the result could be hugely different with a case where you bring it to a third or fourth tier city court. So it's very important for us to choose the right jurisdiction at the very beginning. And it is never an overestimate for us to say that if you choose the right jurisdiction, you could have achieved the 50% of the success. So next one, please. So for instance, if we think Beijing is a good jurisdiction, we as a right holder probably want to understand more about the practice there. From this slide, you will see that the damages claimed and the proceeding duration average and all the other important information. In this slide, I mainly want to talk about one point, which is that pie chart. As you can see, the compensation part, the blue one, you will see 3 types of compensation base. That is because according to Chinese IP laws, the court will mainly award damages in 3 ways. One is the illegal income of the defendant, and one is the loss of the profit suffered by the plaintiff. And the third one is that if you cannot have any evidence to prove those 2, then the judge will award damages based on the statutory damages, which means the plaintiff need to provide the evidence showing the general length, the history of the infringement, the geographical coverage of the infringement, the scale of that, and also the bad faith. And then the court will taking all of them into consideration and then award the damages. And also for that process duration, you will see it doesn't look bad because according to that, within 6 to 7 months, a case can be concluded from the filing date. But I have to say here, because most of the clients we are dealing with are foreign clients. And in China, for the foreign plaintiff, if they bring a case to the court, the court didn't have any time limit to conclude the case. It's not like a case where both plaintiff and the defendant are the Chinese domestic, which means the court need to finish that case within 6 months. Okay, next slide, please. And also, if you try to understand your peers' situation, your industry, whether they are very active to bring the case to the court, you can also get some general ideas from the system. And also, like I mentioned, city comparison, you have different criteria to understand that. And next one, please. If you want to learn more details about this, about some situation, such as parties' names or the law firms or lawyers involved, we have the Cielo team here in China who are ready to help, and they can provide the data analysis tailored to your case. Sorry. Yeah, please, next one. So already, I think that I have already covered this part. So from they have several different purposes for the plaintiff to use the Cielo system, but at most, or at least, I think it will just give you a great idea which court you should go to before you choose your jurisdiction. And also, it will have some trend for you to understand the China's judicial IP practice. Yeah, next one, please. So as I mentioned, there are 2 rules for all the IP dispute enforcement in China. Basically, they are administrative route, and another one is a civil case, civil proceeding. There are 2 parallel rules, which means you don't need to go to administrative first and then go to the civil. So next one, please. The patent enforcement rules, the administrative route, just to give the people some idea. In China, we have the CNIPA. That means China National Intellectual Property administration. Over the last 2 years, CNIPA has undergone some restructure, which means they have the authority to handle various IP disputes. Previously, the authority are quite different. They belong to different entity. Now, people try to centralize all the functions of enforcement into one. So that's how CNIPA works. And in terms of the enforcement in different places, you can go to the local IPO, which means the local intellectual property office for the patent enforcement. For the court route, it's pretty simple. The plaintiff can go to the court directly to file a patent dispute. But for patent-related disputes, you need to go to the intermediate people's court or IP court or the courts where the Supreme People's Court designated. So it's not like the trademark or copyright, which more basic rules can also handle the disputes as well. And also for the second instance court, especially in terms of the invention patent and utility model patent, the Supreme People's Court will directly handle the appeal. In terms of the timeline and the cost, as you can see from this chart, that the administrative route is more time and cost effective, but that's mainly in my experience in theory. In many cases, if the case can be a little bit complicated, it will either be dropped or it will last longer than you expected. The reason is because the authority officials compared with judges, they are not that sophisticated. They are not have a very strong motivation to do the enforcement proactively, especially when they are lacking the knowledge or of the patent itself or the technology involved. So in some very ideal case scenario where the other party is very willing to cooperate, the IPO officials would like to help to mediate the case first. And if that doesn't work out, then probably they will drop the case or they will issue some penalty requesting the other parties to stop the infringement if that case is very, very straightforward. But for the cases, for the civil litigation cases, no matter how complicated it could be, the judge will have to examine them. And if they have any very sophisticated technical issues involved, they can rely on the judgment, the independent advice of the technical investigator. In terms of evidence collection, I should say both of them, they need the plaintiff to provide the legal documents notarized and legalized in other countries, and also, but for the administrative route, because the official will only need the other parties to stop, so they don't need the plaintiff or the IP holder to provide sufficient evidence to prove their damages. But for the court, most plaintiff, they will try to recover their cost, recover their damages. So they need to provide huge amount of evidence to prove the damages they suffered. That's why the evidence collection part are quite different. Next one, please. All right, I hope that you can just have some general idea about the administrative route and the litigation in China. And now I'm going to walk you through one case study. This is about patent litigation in China. The products, our client's product's name is Bakugan. In short terms, these products, the technical feature involved is the rollable shape. As you can see there, the round shape. The magnetics will trigger a transformation inside, which means if you throw this round ball into a card, it will immediately pop up and a character will come out after that. And you can also close it. So the key technology feature involved is magnetics trigger the transformation. The other party on the right side of this slide is Lingdong, and they totally copied our client's ideas of this design of this invention patent. Of course, they have made some changes, such as they didn't have the round shape, but egg-like shape. And also the inside characters are quite different with ours, but completely they have fallen into the protection range of our client's invention patent. So based upon our analysis of that patent infringement, we think we are very confident about this case. And now, next slide, please. And when we decided that this target is very aggressive and we need to take aggressive actions against them, the first three elements we need to decide is about the defendants, and then the jurisdictions, and then the damages. So who are the defendants? According to our desktop search, we have noticed that the producer and brand name obviously should be involved. And another two OEM manufacturers are very, very key. And third one, or the fourth one here, is about a seller, the Suzhou distributor. It is not that big. I mean, it is not that important in terms of the infringement liability, but it is super important because for the jurisdiction choice. Because if we think the jurisdiction of Suzhou Intermediate People's Court, we need to find a defendant located there so that our case can be examined by this Suzhou court. So we choose a right target there. And then after the defendant and the jurisdiction has been decided, we then will come to the damages claim. We have noticed that from the online search that this party is really aggressive and they have achieved a big amount of sales volume in the last 2 years. But how to prove them? We normally have three ways. The first way is that we will send our own investigator into their factory using some business pretext and try to get some information from their boss or other senior salesman about the business ambition of this company, the history, the coverage, the scale of the infringement, so that and also we will notarize the conversation between our investigator and their salesman. This is a very important evidence. And the second evidence is about online sales. As we have noticed that this infringer has been selling the infringing items over many major platforms in China, we need to prove them as well. So we have arranged some notarize over internet. The third one is offline sales. We have learned from the businessmen and their public information that they have sold the products across China. So we have on selected basis sent the investigator into 17 cities and purchased the infringing items from different stores. So in total, we have arranged more than 100 purchases. Next one slide, please. With all the evidence in place, we also have applied for the evidence and evidence preservation, and applied the investigator to issue apply the court to issue an investigation order, and we have managed to obtain the data of the sales value of the Alibaba and other platforms. And for that information, you can see from this timeline, we obtained the final information until the first time when we have the court hearing. So in this timeline, the key steps is the first one, of course, case filing, and immediately the other party filed the objection of the jurisdiction, which is a normal tricks that most defendants will always play. They try to delay the whole process. And 1 month after that, the Suzhou court rejected that objection. And then the other party appealed with a higher court of Jiangsu province. After 7 months, the Jiangsu province rejected that objection. And then we have the first evidence exchange in November 2018. And after several months, we have the real formal meeting. And until almost 1 year later, we get the first instance judgment. So in total, this case has been through more than 2 years, which compared to most of other cases is pretty long. But given the elements that the process of the rejection of the objection of the jurisdiction involved, and also given the time when China and the US have that trade war, the political elements has been involved. So it doesn't surprise us too much about that. But we have to bear in mind that political issues sometimes can be an issue, especially for the high-profile cases. And also, one more thing I want to note here is that the evidence exchange and the court hearing, sometimes they are not separated. They can be combined together for the straightforward case. But because our case is quite sophisticated and huge amount of evidence has been involved, that's why the judge has to divide them separately. Next one, please. Yeah, the damages calculation is very important. As I mentioned, according to the data we achieved from the online platforms, we have a very accurate sales value of the online infringing items. But offline infringing items is a little bit difficult to calculate. So we have collected the industry white paper where it mentioned that the ratio between online and offline sales in toy industry is about 3 to 7. And then we come up with this figure, which was supported by the court. After combining them together, it's a total sales revenue of the infringing items, but we claim the illegal profits, not the revenue. So we had to find a good profit rate. Then we presented 6 listed companies in toy industry and come up with the average profit rate, which is 12.8. And then based on all those numbers, we finally conclude that the illegal profits of this infringer has even beyond 16 million RMB. And this figure again has been supported by the court. And also we provided other evidence about the legal cost. Next one, please. Because according to our records, this is so far the highest patent infringement damages for foreign plaintiff in China. So it has aroused great attention globally. And the client is very happy with that because not only the other party has stopped infringement almost after 1 year we filed the case, but also because the high damages, it sent out very strong deterrence to the whole toy industry. So from this perspective, we think, I have to say this case is a little bit different in some way because so much evidence has been improved to prove these high damages. But on the other hand, it is a quite typical case because I just want to remind you the key characters of the patent litigation, which is the other party normally will play the tricks of delaying the whole process by challenging the jurisdiction, and sometimes they will also try to invalidate our patent. In this case, they ask one individual to do that as well, but the court didn't accept that. And also, you know, online and offline sales, evidence collection, they are all quite common in China now. The only thing that I think we don't need to worry too much is about the enforcement of judgment, because the defendant in this case is a top 3 or top 5 toy players in China. So we don't need to worry too much about whether we can actually collect the money. But in most other cases, it's not always the case. So probably in other cases, if possible, we will also try to arrange some asset preservation beforehand. So that's all for me. Thank you.
Thank you very much for a great presentation, Carol. Very, very interesting. I noted that you said that the reasonable expenses were awarded. Could you comment some more about that? How does it work in China? Are you normally awarded if you win a case? Do the loser, do they have to pay all your costs for attorneys' fees, court fees, everything, or how is it calculated?
Yeah, thank you, Marlene. The legal cost, we call that legal cost, mainly including several parts. One is about the attorney fee, which is mainly our time fee. And then for the notarization fee and disbursement, all those work that need to be done to collect the evidence. And also the litigation fee means that the court will also charge the plaintiff a fee for them to filing this case. And we can also request the other party to pay that fee as well. So in addition to that, we can, of course, request the other party to pay the damages to our clients. So all the legal disbursement can be claimed to be paid by the other party. And if we have very sophisticated or very solid evidence to show our legal cost, the court will support that. In our case that I demonstrated just now, the court fully supported our legal cost claim.
When you talk about court fees, I mean, in Sweden we don't have any court fees, just a nominal fee. And you said the plaintiff has to pay the court fee in advance, and then it can be requested from the other party if the plaintiff wins. But about how high are the court fees?
The court fees, normally it is there's a preparation between the damages, the claimed damages, and the court fee. Like how much percent of the damages you claimed will be the court fee. So it is really relevant to the damages you are going to claim. Mm-hmm. I can give you an example. For this case, in our current case, we claimed 15 million RMB as a claimed damages, and we paid the litigation fee around 110,000 RMB, which is about which is about 14,000 USD.
And is that about 1% or how much?
Yeah,
about 1%. So that's sort of the nominal amount.
Yeah.
If you're actually awarded damages in a Chinese court, how do you, as a Swedish company, go about in actually getting the money from the company into Sweden? Is this generally a problem, or?
I think there are several challenges over there. First of all, like I mentioned, if the other party, if you don't believe that the other party are willing to pay, even though you win the case, you'd better take the steps such as the assets preservation, which means when you file the case, you just apply the court to freeze the other party's assets, so that when you receive the favorable judgments, you can guarantee you can receive the damages. And that is the first challenge. If you don't do that, sometimes it's quite difficult for you to actually collect the damages. And after even you have collected the damages, to send the money, to wire the money out of China to like Sweden is a little bit challenging as well, because China has a very strict foreign exchange control. So we will request the other party to directly wire the money to our client. Or if the client asked Lu Sheng, the law firm, to transfer the money to them, then probably there's some tax will be incurred.
Mm-hmm. Do you have any other questions around costs?
Yes, Marlene's question addresses one of the concerns that many Swedish and Western companies have, is really getting the damages out. And I realize that there's a lot of dispute resolution going on in China. And does this have, does the fact of choice of jurisdiction where you litigate increase the possibility to get the damages out of China if you want to, or simply more courts, more international in that context. And maybe, and then I have another reflection. Sweden is a very centralized country. We are very unused to talking about first, second, and third tier cities. Can you reflect a little bit upon the quality of the courts in the various cities from that context?
Yeah, sure. China, you probably have, China is very, very different with Sweden, of course, and the economic development in different places vary hugely. So that means the jurisdiction, can be quite different. The judge, their background, educational background, their understanding of the laws sometimes are different. But still, I have to say, China saw the judge as the most important career. So they try to put the best people into that position. So even though in the third tier or fourth tier cities, the judge's capability probably a little bit different with Beijing or Shanghai, but still they are very protected, they're very respected, and they have a great passion to learn new things. So I cannot say it is always bad to choose those jurisdictions. Sometimes we will try to get more information about them, such as we will, by using Cielo to see, whether they're not that bad, or sometimes we will check the papers that the judges, published to understand their way of thinking. So from that perspective, I have to say, generally, we prefer to go to the Beijing, Shanghai, Guangzhou IP courts, or the courts in those good jurisdictions, like I mentioned, Suzhou. But if we have to, sometimes if we don't have any opportunity to choose the best jurisdiction, then we can still try those other jurisdictions as long as we have, as long as we have tried everything.
Carol, a question popped up here now, and it's posed by one of our listeners or viewers, and it's a very standardized concern that many companies have. And maybe you want to address that in the light of CELA or any other way. And the question is, do you see any general trends as to the success rate of Swedish European companies enforcing the rights in China? So it's are foreign companies discriminated against in IP cases?
Yeah, I think that's a common concern that many foreign, especially the US or European clients had. Actually, according to Cielo data, or from my personal experience, I didn't have the strong feeling that foreign brand owner or IP holder will be discriminated in the Chinese courts. In fact, they're pretty respected. That's also due to China's culture for a long time. They respect especially the Western countries. And so I think the trend, the enforcement rate, I think just now I have demonstrated one slide, which is talking about the successful rate. And you can see in that one, about 70% plaintiff has successfully get their rights protected. And for the foreign, especially European or Sweden clients, I think that number can even become bigger. Because most of the European clients, they are pretty, conservative. They will go to the court when they have to, and when they have to go to the court, they will make sure that they have a very solid legal grounds. And the lawyers normally will provide a very detailed analysis beforehand. So yeah, in general, it's quite strong.
Yes, and that's also, you support also my and our experience here. So I really wish to encourage all the listeners to start using the CELA database, because it clearly shows that, as Carol, as you say, that actually foreign companies have a higher success rate than domestic Chinese in terms of IP of the cases that we have in our database, which is 65,000 cases. And yeah, that is a very important fact. So please take that with you. I think that is one of the major findings of this seminar, and always a question of concern that comes up. over to you again, a Corona move.
A Corona move, over to Malin. I have a question about how it actually works in the court. Are there technical judges or are all the judges legal judges? How do you go about if you have a technically complicated patent case, basically?
Most all the judges are actually, they're just legal judges. They don't have a sophisticated understanding about the technology. So in the patent litigation, we have a procedure or the system where the technical investigation officer will be involved in some patent cases. If the judge couldn't understand that technology, they will ask the person to be involved, and that technical investigation officer was assigned by the court rather than both parties.
And is your experience that this generally works? I mean, even if this office is involved, it's still then the court who has to make the ruling. And if it's very technically complicated, this must be difficult for the court. But is it your understanding that it generally works anyhow?
Yeah, it generally works because the technical investigation officer, they will provide very detailed analysis about the techniques involved. But I cannot say it works in some way, from procedure perspective. But in our maybe 1 or 2 cases, we have found out that the technical investigation officer tend to approach the problem in a very conservative way, which means sometimes if we have seen some controversial dispute and our client's legal grounds is not that solid, then the technical investigation officer sometimes they will play a kind of a negative role for our case.
Another question about injunctions. I understand that it's possible to use interim injunctions in China. Is this widely used and is it widely granted if you ask for it?
No, it is not widely used. The interim injunction, because you have to prove the fact that you have the overwhelming evidence to prove that if the court didn't issue this interim injunction, then you don't have any chance to get the damages back. And also, in addition to that, the case needs to be more black and white, which means almost, not very controversial in terms of the nature of the infringement. So in practice, we don't see many interim injunctions granted.
I think this is generally a good thing because not sure that all the audience knows what an interim injunction is, but that is actually when the court orders you to stop selling your product until the final decision has been made by the court. And I know that a lot of Swedish companies, European countries, are afraid that the other party may be granted an interim injunction against them in a court proceeding that they don't understand. But this is not a widespread
no.
Okay.
Yeah.
Over to Thomas.
Hi again, Carol.
Hi, Thomas.
I received a question here when it comes to the 2 routes that you described, the administrative and the court route. When do you recommend to use the administrative path or route?
That's a very good question. In fact, when the case is very straightforward, and we probably already have some favorable judgment in hand, and we just want to stop other, smaller scaled infringers, then we would probably use this IPO process. Because the authorities, they have the judgment, on hand, and they know that is a straightforward case, so they're willing to take that.
So that is almost like a surrogate for an interim injunction in civil court, you could say, providing that the case is very clear.
Yeah.
Okay, and what is the cost of an administrative route in relation to the civil route for a Swedish plaintiff?
Yeah, I think, sorry, I forgot to mention one point,
Yeah.
which is about the administrative route. It's not every, single authority or IPO officer would like to do that. Especially so far, according to our experience, we only noticed that in Guangdong area and in some part of the Jiangsu area, they are willing to do the IPO enforcement. But for most of other IPOs, they are very reluctant. Like I mentioned, sometimes the local protectionism still prevailing, so they're very reluctant to take any action. And in terms of the cost, if everything goes very smoothly, the administrative route would be around 15,000 US dollars to 20,000 US dollars, as opposed to patent litigation, which is more like 40,000 US dollars to 70,000 US dollars. But it can be more sometimes if, like our case. Yeah.
But still, if you compare litigation costs in China in relation to the litigation costs that we are used to in the Western Hemisphere, they are very, very low, is our experience.
Yeah,
definitely.
Yeah.
I have one more question relating to the duration of first case matters in IP courts. I think your SAILA excerpt showed the first instance average case of 6.7 months. And it said, it asks here, is it the same for domestic and international clients?
I mean, 6 months, we need to finish that case within 6 months, you mean?
Yeah, is there a rule for that for national clients and that differs from international clients?
Yeah, that's a different, that's the specific rule that for the domestic dispute between two domestic parties, the court need to finish the case within 6 months.
And why is it different for international clients?
It's because of foreign clients, there are many, legal documents and the evidence will be in other languages. So there's supposed to be more, time to re-examine those cases. And also they try to provide more time for the plaintiff for them to prepare the evidence.
Yeah. Over to you, Malin.
You mentioned that you used your own investigator for collecting evidence in the Spin Master case. Is that something that Rouse can generally help with? If a Swedish company suspects patent infringement in China, do we have investigators that can help to collect this evidence, or how do you go about?
Yes, we do have the in-house investigator in Rouse. We have probably the best investigator who have more than 20 years of experience in this industry. So we think for especially those very high-profile cases, it's very important for the investigator to approach the other party, not only because they can collect some evidence, but also because they will know the true information, which sometimes will not be disclosed in their public website. So we of course will provide that support to our Sweden clients. And in the meanwhile, we also have some other third-party investigation agencies working with us. They, depending on the jurisdiction, depending on their industry advantage, they can provide, different support to us.
I also have a question about IP patent invalidation. In Sweden, it's more or less the rule that if somebody accuses you of patent infringement, there will be a counterclaim for patent invalidation. Is this generally the case in China as well, that you almost always have these two proceedings, and are they handled as separate proceedings or together, or how does this work? Yeah,
there are separate proceedings on that. For the infringement, it's a civil proceeding. But, as I mentioned in that Spin Master case, when we filed that case, the other parties, they try to invalidate our patent as well, but they applied that invalidation with the CNIPA, the China National Intellectual Property Administration. So that is an administrative route rather than a civil proceeding route. So there are two routes in parallel. But how the judge are going to approach the issues there? Normally for the invention patent cases, where they invalidate the patent is pretty solid and sustained, the judge didn't intend to, suspend the court hearing. They will go ahead, just examine the case further, especially if the invention patent has been already sustained after suffering, the attacks from other parties' invalidation. But for the utility model or for the design patent, which the CNIPO didn't need to undergo any substantial examination when granting the patents, sometimes a judge will wait until the invalidation result comes out.
But the court never addresses the question of invalidation. No. This is always an administrative proceeding.
Yeah. And if they actually, first of all, it's an administrative route, and then if the CNIPA, gives some decision on that case, they, as a party, if they're not happy, they can still file an administrative litigation with the IP court. But that administrative IP litigation still considered as to be a totally separate civil proceeding with
Okay.
Totally different proceeding with a civil proceeding. Yeah.
Okay. Thank you. Over to you, Thomas.
Hi again, Carol.
Yeah.
I have a question regarding to the New Balance case that I gave some thought to. I was very curious about the quantity of shops decreasing during the time of the proceedings. I think that the infringer had 2,600 shops, and at the end of the proceedings they had reduced the quantity to 60.
Yeah.
Can you describe the process, and was that because of wear and tear and because the defendant became tired, or what was the reason for that decrease?
I think, honestly, there are probably various reasons for that. One of the reasons we understand is because of the attack. We're going after them so seriously by not only, initiating the civil proceeding, but also we have frozen their trademark rights. They have many trademark rights. We have also done some trademark invalidation against their trademarks, so they can feel they are suffered by all-round attack. But on the other hand, because this infringer has been suffering the all-round attack, the other parasite infringers coming out. So probably they are also one of the reasons. So we cannot 100% say that all the credit should go to this civil litigation, but we just got the feeling that if you are taking really serious aggressive actions against such a big infringer, it will work out, especially if we try to stop them. Because as a comparison, the client used to take a civil proceeding against the same infringer long time ago, but in that civil proceeding, even the client has got a favorable judgment, but the damages awarded is pretty minimum. So this infringer didn't take it seriously. So I think you can see the difference here. I think the whole purpose is that we need to make the other party feel the real stress, real pain from us.
A follow-up. We have a colleague, Jin Ling, and she usually says that, copying in China is not a moral issue, she says, in comparison to the way we have been brought up in Europe. We say that we have Luther on our shoulder. But what are your thoughts about that and the development in the Chinese society about copying and the importance that it has in Chinese society today, also taking into consideration the data showing that foreign companies are not discriminated against in terms of IP conflict?
Okay, sure. I honestly cannot agree with Ling on that point because I can give you a data. You remember that New Balance case?
Yeah.
Also, I mentioned that case become one of the hottest topic in social media, and we have actually monitored the comments. And according to our monitoring, we have found out 95% of the comments from the viewer towards that news is that this is absolutely great news because the pirate brands have finally been attacked. So that means, especially for social media, they are more, young people, and the younger generation of Chinese people, they respect the original one. I cannot say that all of them are doing that, but I have to say the mainstream of the younger generation, even including the middle class, I think they respect the original one. That's for sure.
Yeah, and our experience here is also that there is a shift in direction of commerce, as we a couple of years ago had the privilege to be able to represent the Chinese right owner against the Swedish infringer. So things also happen in that context.
Yeah.
It's 9:25. We have gone through a series of questions. What do you say, Carol and Malin? Are we wrapping up?
I think we're wrapping up. To some ways.
So here are some key takeaways, and Malin and Carol, feel free to jump in. There are efficient procedures for addressing infringement in China. We know that. We have a business in China on 4 different locations that works and represents our clients in a consistent way to achieve the results, which are also received. But of course, China is a different context than Europe. It's a different culture. There are, of course, things we have to consider. We need you, Carol, when we do work in China. We need our investigators in China to do the work. There are stereotypes about China. There are always stereotypes about foreign places. And in the case of China, it is that foreign companies are discriminated against. But we do not see that in the data when it comes to patent or IP infringement. On the contrary, we see that foreign companies are treated generally even better than domestic. And of course, there is an interest to have a system in China that also works for foreign companies that use China in its complex value networks to produce value for clients. So the system has to work. We have seen historically many stereotypes also when it comes to technology theft and things about China. There are specific issues in China. I think we can all consent to that fact. But many of the issues arise because we don't have you, Carol, and our colleagues in Rouse who gives us the right advice when it comes to technology transfer, for example. China is complex, but China is not complicated. So in order to understand the complex environment, we just have to know the facts and know how to handle it. China is possible. IP litigation in China is possible. Patent infringement litigation in China is possible for Swedish entities. So those are the key takeaways. Do you want to add anything, Carol or Malin?
From my perspective, I just feel China is also reasonably quick and cheap for litigation compared to what we are used to in Europe. That was my big revelation when I delved into this. I mean, you say that 2 years on the Spin Master case in both instances was relatively long. I mean, from our perspective, that is super quick.
Malin, how long have you been working in your latest patent case here in Sweden?
We haven't even got to the first instance court hearing, and we're already up to 3 years or so.
Okay, sorry, Malin, for that Spin Master case, it's still the first instance time.
It's still the first instance. Okay. Yeah, but it was still quick, I must say.
Okay, thank you, dear audience. Thank you for taking your morning with us. We hope that you had a nice breakfast while watching us, and I hope that you stayed. I hope that there are still many questions and concerns that you may have. Feel free to contact us here in Stockholm or Carol directly, whatever feels more convenient for you. And we will follow up and hear about your comments about the webinar and try to improve. We also would like to inform you of future webinars coming. Next week we have a couple of webinars, Malin. Are you responsible for how to, I think we have a webinar on how to patent for free or something.
How to patent when you can't afford it.
How to patent when you can't afford it in these times. So that is a topic for next week. So tune in next week, and thank you for joining. Thank you, Carol, very much.
Thank you, Thomas, Malin. Thank you, everybody. Bye.